Hello everyone and welcome to the virtual TARGETjobs National Pupillage Fair. I'm Emily, I'm one of the TARGETjobs law editors and I'm going to be taking some of your questions at the end. But first, I'm delighted to welcome Heloise and Nathan from the Free Representation Unit, or FRU for short. We're always really grateful to have the FRU at our fairs. The work they do in representing those who can't represent themselves is absolutely vital, and it's also one of the best ways for you to get experience at the bar, to find out whether it suits you and for something to put on your pupillage applications. Heloise and Nathan will tell you a bit more about what they do and what it takes to volunteer with them, so I'll hand over to them now.
Thank you, Emily. Good afternoon, everyone. Welcome to the FRU talk. We are going to discuss a little bit about what we do as an organisation, what your role is as a volunteer, and then talk a little bit about our respective areas. So I do social security and my colleague Heloise does employment law. And we'll talk a little bit about how you prep a case, what tribunals look like, and we'll end with what you get out of it, essentially, and how volunteering with FRU will deliver you to the promised land that is pupillage, hopefully. Anyway, so let's begin with what is the Free Representation Unit. So we're a legal charity, and we have two aims or two guiding principles in which we orientate ourselves. The first one is that we provide legal representation to people who otherwise would not be able to afford it. These are individuals who cannot get legal aid and they do not have the funds to hire private legal representation. And the second principle is that we give people at the start of their careers who are training or who have just qualified or are students still doing the bar course, an opportunity to get real life tribunal experience and real contact with clients and real drafting skills and legal research under fire. So that's a little bit about what FRU is, essentially. Now we have two areas of law that we cover. One is social security, which I'll be talking about, and then employment law. There is some scope for something called criminal injuries, but there's not much of that. So those are the two areas, essentially, and they're a little bit different in how they run. And what Heloise and I do, we're the assistant legal officers. So what we do is we help you supervise you whilst you're running cases and doing things like that. And you'll be a volunteer for us. You'll sign the cases out from us. You'll do the legal research, but you'll be running it. It will be us helping you guide through it. It will be us that are giving you some suggestions maybe on tactics or where to look in terms of research. But really, this will be your project and you'll be taking it from start to finish, from the initial phone call to the client all the way through to an appeal if it happens. So how does one become a FRU volunteer? Well, we have a training day and a test. It's normally run over the course of 2 days and a weekend. And then afterwards, you'll have some time to do a written test. Now, the next training day doesn't have any dates fixed as of yet, but it will be sometime in spring. And what I recommend everyone does is that they go onto the FRU website and signs up to the newsletter. And what the newsletter will do is drop you an email when it goes live and when you can apply for the tests. And that way that you can have the best chance of securing your place. It's a first come, first serve basis, and it does tend to sell out. So I would really recommend you doing that. And like I said, it will be in the springtime. So I'm going to pass you over now to Heloise, who's going to talk a little bit about what employment law is like at the FRU.
Thanks, Nathan. So employment law essentially involves any cases where an employee has brought a claim against their employer. And at FRU, you have the opportunity to represent clients in both the Employment Tribunal and actually also the Employment Appeal Tribunal as well, if you are bringing grounds of appeal and or you stay on long enough with us. So the hearings that you could be representing a client in can include preliminary hearings for case management. They can be final hearings and also remedy hearings. And the claims, they range from something like unfair dismissal all the way through to discrimination claims such as a failure to make reasonable adjustments for a disability. And we grade cases according to their complexity. So provided volunteers have got the time and availability, you're able to work your way up to the more complex cases. An example of that would be when you start, you'd be doing an any rep case, perhaps something like unfair dismissal or unlawful deduction of wages. And as I say, you can work your way up to something more complicated. Over to you, Nathan.
Okay, social security law, what is that? I'm presuming that most of you aren't too sure. And what I would say that is in a word is benefits law. And it's actually a part of administrative law, because essentially what you're doing is you're appealing a decision that the Secretary of State has made about whether or not someone is entitled to benefits. It's quite a complicated area of law, and it's very bureaucratic, and it's very conceptual. And essentially we deal with 3 types of benefit mainly, and that would be universal credit, personal independence payment, and to a lesser extent now, because it's being phased out, employment and support allowance. And those are really the bread and butter kind of cases that we get. And normally what it is a matter of is that not that the Secretary of State says that the person is not disabled or does not have some difficulty, but they dispute, in fact, actually the level of difficulty that the person has. So obviously you're going to be dealing with very vulnerable clients, many of whom have quite serious mental health issues. Many don't speak English as a first language. And it is really good exposure for you if you're thinking of something like criminal law or family law, where you're going to be interacting with members of the public that probably do not come from the same background as you, and probably do have certain vulnerabilities that you may not be used to experiencing. And as a result, my experience is that the majority of our clients are very, very thankful to have had us running the case with them. They feel very supported, and your work really will make a massive difference to whether or not they can get their entitlement, because obviously they're quite people in quite difficult financial situations. So that extra, excuse me, that extra £100 a week can really mean a massive difference to them. So we're now going to move over to what preparation is like in terms of the cases. Heloise, do you want to start us off with employment?
Yes, thank you. I think I will pick up a little bit about what you were saying about clients. I think that's also very true for employment cases. You have clients who are very vulnerable, who've lost their jobs, who are not able to pay their rent. I had a client who did in fact go on to lose his house simply because the respondent refused to pay, even though he lost the case. So it is something where, everybody involved can be very vulnerable. They vary, of course. And I think one other thing to add about clients is that the employment tribunal for them can be very daunting, because this is the first time they're ever dealing with some kind of legal case themselves. So to give you an idea of how volunteering works, I'm going to take you through preparing for an employment case. So after you've discussed with a legal officer your availability for hearing, we hold what we call a ratification. And during that, you demonstrate that you've thoroughly read and understood the claim and that you've done the relevant legal research. Then you contact the client and you offer them representation. So if they say yes, that's the moment at which you are now in charge of the case. And obviously there's a lot of responsibility that comes with that, but it's also a really valuable opportunity for you to gain real life legal experience. So if I break this down into the skills that you'll learn, when you hold your first conference, you learn conference skills and interview skills. The difference between asking an open question, tell me your story, what's happened here, and more closed questions. Okay, so I've seen in this document, it says that you sent an inappropriate message to so-and-so and that you deny this, but the message in the document says X, Y, and Z. Do you really think that we can say such and such about this? And that might be a question for later rather than in your first conference, but it's an example of how you're practicing these skills as you go through. And that first conference is also a really great opportunity to build a positive relationship with a client from the beginning. I think to add as well about clients, a lot of them, because they've been representing themselves from the beginning, it's very emotional for them, it's very stressful. This case is their life. And so you have to sometimes be very sensitive about that. Before you get to the tribunal, primarily what you're doing is preparing physical documents for that hearing itself, and also dealing with the respondent's representative. Normally they are represented. So you have your legal research that you have to do. That's very much an ongoing process. You do the bulk at the beginning, but there are matters which arise in the course of the case which you'll need to be looking into as well. You will have a bundle of documents. Now, when you start, there may be one or there may not. If the respondents are represented, they probably will be making that bundle. Sometimes volunteers do in fact do that themselves. There is nothing more frustrating than putting a bundle together and realizing that you've accidentally only photocopied one side of a double-sided document, and you now have to redo the entire thing. But that process is still important, even if you've not been the one making it. You need to think about what documents are included, should they be. We've had cases where without prejudice communication has been included, and we've needed to point out to the respondent, well, that shouldn't actually be in here. That's not something that can be disclosed to the tribunal. From early on, you also need to be thinking about small issues that you might not jump out at you, like time limits and amendments, and sometimes volunteers do make applications to amend as well. One of the main skills that you'll be learning will be drafting skills. You have the opportunity to draft witness statements, schedules of loss, list of issues, and skeleton arguments. And 3 of those documents I see as sort of being in a kind of relationship with each other. So the list of issues is like the way you frame the case. It is everything the tribunal needs to answer to decide if your client has been unfairly dismissed. And the witness statement is all of your client's evidence, the relevant, detailed evidence that answers those questions, so that when you make your submissions, whether they're oral or in writing, you're saying, look, my client's evidence answers all these questions. She was unfairly dismissed. And the tribunal look at all of that evidence and hear your argument, and they say, yes, I agree with you. They were. Witness statements, they vary in length. You don't want to be conclusionary. And as I say, you need as much relevant detail as possible. I think it's worth adding that because it's not a skill that you actually do learn on the BPTC drafting. I think you do on the LPC. Or at least I didn't. It might have changed now. Another important aspect is negotiation skills. So you'll definitely need to have your schedule of loss ready for that. And you also need to be able to explain to your client what you think the likely outcome of the case will be at tribunal. I've previously described this as being a bit like in a game show. Do I want to open the box? Do I want to take the money? But actually, I think it's not quite like that, because you're needing to advise the client of the merits and the pros and cons of settlement as well. So it's more like giving them an informed guess as to what is in the box, rather than just, that stark choice. And it's really important that we respect the client's autonomy there. I've definitely had cases where I've thought, no, don't accept this. Hold out for more. I'm sure we're going to get everything. And then other cases where I have thought, I really think you should be taking this money, and they haven't wanted to do that, and we've gone on to lose. But it's important to remember it's their case, and they may feel for them it's actually about the principle. So I'll hand back over to you there, Nathan.
Okay, thank you, Heloise. So there are some slight differences between preparation and sort of the things that we'll expect for you in Social Security. But I think, first of all, something we need to point out is, in case the people watching this aren't aware, COVID has happened, and most of us are remote working now as a result. So previously we did have an office in Holborn. We are in the process of upping sticks and moving somewhere. But as of yet, we're doing everything online. And the reason for that is, two reasons. First of all, is to protect our clients, because at Social Security, we've got a lot of very vulnerable people. And the other thing is to protect our volunteers. So everything that you do with us will be, at the moment, remote working. That'll be via phone calls or Teams, and emails. We'll set you up with your own FRU email if you pass the test and when you're taking out cases. So in case anyone was wondering how we're going to manage with that, that's your answer. So Social Security differences. Well, first massive difference is that it is not adversarial. It is an inquisitorial jurisdiction, which means there will not be another side that you're going up against. It means there's not another side that you're going to be sending correspondence to. The DWP, however, will prepare the bundle for you. It will be paginated, and in theory, it should have everything that's in there. In my experience, says that that's not always the case, but all of that will be prepared for you. So your first thing will be to go through that and to get an understanding of it, and then to go do some research. We have some resources for that with Social Security, and then you'll do the ratification just as if you were doing employment law, and then you'll make your client contact. One of the first things that you'll experience with your client, and it's something that comes up in Social Security law, is managing expectations, and also understanding that your client doesn't really understand what the law is. So a good example is that there's a descriptor in personal independence which says, can the claimant manage therapy at home? And most people see the word therapy and they think psychotherapy or something of that nature, but actually it means something a lot more specific and which wouldn't be apparent from looking at it. So that's a conversation you need to have. You need to explain to them what the law is. You need to take their evidence. And there is a really big tactical decision that comes up quite often with Social Security. Now, when you appeal a decision, essentially the decision is remade at the upper tribunal. That means the previous decision is a nullity. And if you've got a client who has got some money, but not all the money they want, it is your duty to let them know that if they appeal, it may be a case that they get nothing. They leave with less than they came with. And that's a decision that you need to let them make for themselves, but you need to inform them about that so that they can make an informed choice. And it goes without saying, but just to reiterate this, is make attendance notes. Please, please, please make attendance notes of everything that you do, because you never know if someone's going to make a complaint. You never know if someone's going to come back and say, actually, you told me to say this. So please just make a nice, succinct, contemporaneous note. You will save yourself such a headache. You'll save us a headache when we're coming to closing the case as well. So the other thing with Social Security is a lot of the time we'll want some medical evidence, and there's a way to go about that. There is a letter that we have on our intranet system that you'll be able to access, and you'll show it to me or one of my team, and we'll send that off to the GP. Obviously, at the moment, the issue is GPs, because of COVID, quite busy. So they tend not to be responding, but there's normally some kind of evidence in the file. We can talk about that as we go. So big difference as well here with Social Security, much smaller cases. It is completely conceivable that if you were to dedicate your summer to this, you could get a couple cases on your CV. Now, that's not just good for your CV, it's good for your skill set, because that means dealing with 3 separate clients, 3 separate personalities and sets of expectations, normally 3 different bits of law, drafting 3 lots of submissions. And it's a good way to hone your skills very quickly. The other good thing about Social Security is that, well, I say good thing, good for you, maybe not the client, is that the DWP are not going to say, we don't stand by this decision. You are going to go to a tribunal. You are going to have your day in court, and you're going to get that experience, and you're going to get that experience of talking to judges. I think there's been a handful of cases where that hasn't happened, but normally it's almost guaranteed that you will go. So you've talked to your client, you've got fantastic attendance notes because I've told you all, and you're now going to draft your written submissions. And it's important to remember they are written submissions. It's not a skeleton argument. This will be a chance for you to work on your written advocacy. Now, I know most of you are going to want to go to the bar because you want to do oral advocacy. You know, I like the sound of my own voice as much as the next person, but written advocacy is a really important skill, especially when it comes to those pupillage apps, because it is the paper sift that you need to survive first to get you in the interview room. And that's where something like Social Security comes in, because you are going to be trying to persuade a panel of judges that your client's case is very strong and that he should have, or she should have, these descriptors. So those are some slight differences between employment and Social Security in terms of preparation. And there's also some slight differences when it comes to tribunals. But I'll hand you over to Heloise to talk a little bit about employment first.
Thanks, Nathan. A couple of points to add to what I was saying about negotiation. So you do actually do the negotiating between yourself, the client, and the respondent as well. It can be all the way up to the door of the court. And like Nathan said about attendance notes, also really important with employment, especially with negotiations, because, you know, if your client has said, yes, I want to take this money, and you're thinking, why are you wanting to do that? If you've got a note that says yes, then you can point to that later. And so obviously that's very positive for you. As I said, it can settle all the way up to the door of the court itself, and sometimes even if you break in the middle. So the tribunal is the moment where all your hard work and preparation come together. And it can be a nerve-wracking experience. I still deal with nerves. I've heard that that's true for barristers, even senior silks. And what I usually do to get through this is thinking about the fact that this would be even more daunting for my client if he or she was representing themselves. Now, the employment tribunal is in the civil courts, so that means that your client's evidence will be presented in writing. So you probably won't be asking them any questions in evidence in chief. You're generally dealing with cross-examination. I have sometimes asked additional questions. It's an interesting skill to develop, and it's something that you do have to be very careful with. I've actually been told off for leading myself, so I do recommend being very careful with that process. Now, cross-examination is probably one of the larger aspects of what happens at the hearing, because that's when the evidence is tested. That's really about you putting your client's case to the respondent's witnesses. And so in a way, it doesn't matter if they deny absolutely everything. I've had cases where a witness has agreed that particular behavior would be inappropriate, and I thought that was a good thing because it could have been seen as a relatively innocuous comment. But in the end, it didn't help me that he agreed with me, because the tribunal accepted that he didn't realize that at the point he made the comment. And if you're wondering what could possibly fit a scenario like that, it was to do with ice cream. It's also in cross-examination where the biggest chance of your entire case being sunk stands. This is when your client is being cross-examined and either says something which completely undermines the idea that they are an employee when you're trying to establish that very fact by saying they can go on holiday whenever they choose, or they do something like, I think, my very first case where I can sum it up with the judge's comment. And here we have a graphic example of your talking over people. It was the most awful moment, but there was nothing that I could do. And if you're there, there's also nothing you can do about that either. You have to wait for redirect. You have to try and deal with it in your oral submissions. Client handling skills is still something that even at the tribunal you're having to deal with. I think probably my most traumatic experience was a client who wanted to confront the person she had accused of sexual harassment. And I had to actually practically pull her away from the door of the respondent's waiting room. So I'm never going to forget that experience. You're also having to deal with all of the evidence and putting that to the witnesses and referring to it in your submissions. So it's really important that you know your bundle. You can overdo this. I had so many sticky notes on one occasion, I couldn't find anything. So it's important to be careful there too. Finally, you come to the submissions. Obviously, you are going up against the respondent at this point, so you have to be thinking about what kind of arguments they might be making and responding to what's actually happened in the evidence that you've heard. So that may be by adding into written submissions, or it might be elaborating or altering what you've already got in your skeleton argument. And as I said before, it's really the moment where everything comes together and you try and persuade a tribunal that your client's been unfairly dismissed, or your client's been sexually harassed, or whatever the argument is about. And then the tribunal either make their decision then, or they reserve their decision. But in any event, you then need to think about, can we appeal this? Particularly if you've lost. And can the respondent appeal this if you've won? And in that scenario, you might very well be writing grounds of appeal and representing a client at the appeal tribunal later down the line. If you've been successful, you then have to talk about remedy and argue and advocate for your client to get the most money possible. Can I hand back to you, Nathan?
I apologize for that. My burglar alarm went off. It's been playing up. Yeah, not great timing. Excuse me. Yeah, so Social Security, where's some differences? So there won't be a witness statement. A lot of that stuff will be covered in your written submissions, and there won't be cross in the same way. So essentially you'll get to the tribunal and they're set up in a way that's very informal. And the idea is that so people without legal knowledge or without representation can navigate it successfully in theory, but make of that what you will. And your client will be very nervous and they'll go in. This is back when we had physical hearings. We'll talk a little bit about how that's changed now. But there'll be 3 panel members typically. One will be a judge. One will be someone who specializes in disability, normally something like a disabilities rights advocate. And the other will be a doctor. And essentially the format will be like this. They'll ask your client some questions about things that you've raised in your submissions, or perhaps things that aren't in your submissions. And then you'll get a chance to answer some questions of your client. And then finally, you'll have some chance to give some oral submissions on anything that's come up that you haven't covered in your written submissions. Now, obviously there in that time frame, there is a limited scope for oral advocacy, but this actually teaches you a really important skill that you won't pick up on the bar course, which is sometimes less is more, and it's best to say nothing at all. The whole time that you're in the tribunal, you are thinking tactically. And this is where it really, really comes down to you having a good knowledge of the law, having a good knowledge of what's in that bundle, and a good knowledge of your client as well. So they'll be asking questions and you're scribbling furiously and you're thinking, okay, I need this, I need this, I need this to get this descriptor or that descriptor. It's a points-based system. So you need certain amounts of points to get over the line. And so you're listening, always thinking about what it is that you need to elicit from your client. And sometimes, and it's not unusual for this to happen, is that your client has said, I can't do this, I can't go to the shops on my own, I can't do anything. And you've built a whole case around that and you're feeling very confident at this stage. They get there and it seems to be going really, really well. And suddenly they start talking about all the times they go to the shop on their own and how it's a daily occurrence for them. And this is the first time you've heard of it. And in fact, actually contradicts everything that you've said up until that point. And if you're anything like me at this stage, your palms will be sweating a little bit whilst you're trying to think, what should I do about this? And I'll give you one example where that happened. But the evidence that my client had given previously, I felt was probably enough to win the case for us. And now she's sinking the case. Okay, fine. And I have to make a tactical decision. Do I ask her some questions, not knowing what on earth she is going to say and risk losing more points? Or do I add nothing and just hope that what she said previously was enough? And so I made the decision not to ask any questions, not to give any oral submissions, and to try and get out of there as sort of essentially as quickly as possible. And we won, we were successful. That's a high level tactical decision where you're trying to weigh up cons and pros whilst taking a note and keeping an eye on your client, seeing how they're doing and how they're holding up. And it led to me saying nothing at all, but that's a good example of sometimes the best advocacy is saying nothing at all. Typically then you'll get the decision. Back when we were in person, a lot of the time you would get it immediately. At the moment, the tribunal services is calling people, they're sending emails, they're sending mail. It really varies on what's going on at the moment. But I think touch now on what tribunals are like that COVID is here. And what we do now is we do telephone hearings. They're not Zoom, they're not Skype or anything like that. Clients can request an in-person hearing. Most don't, but some people do have communication issues, and so they will ask for an in-person hearing. So you'll get a call on the day, and then you'll have the judge introduce themselves, and it will go ahead like that. It's much the same, but there is something you want to tell your clients, and you want to be aware of yourself, is they can't see your client. And if your client has serious physical disabilities, then they've lost a lot of that. Because I've had a case where I was almost wheeling my client into the tribunal room. And to be honest with you, when you're at that stage, you're pretty much home and dry before you've even opened your mouth. But in this case, obviously, if you're on the phone, they can't see that. So you need to make your client aware that if they don't say anything, and this is their opportunity to say something, then the tribunal probably won't be able to intuit in the same way what the nature of their disability is, because they haven't got sight to rely on. So I think those are some of the main differences, and the DWP won't be there typically. Now that does change a little bit. When you start doing a few cases for us and you become an experienced rep, then you'll start doing things that are very conceptual. The DWP will turn up if it's an overpayments case. You will essentially be giving in skeletons, and you'll be doing submissions as if it was a typical trial or tribunal hearing in the way that you imagine. So that's different if as and when you become more experienced as a rep. And I think also something I forgot to mention to you guys is at the moment, because of the situation that we're having with COVID, with Social Security, we have got fewer cases coming in than we typically would. We're not entirely sure why that is, and we're trying to look at ways of freeing up more cases. But it was a case before that we were doing a lot more, and now that scope has limited somewhat. And hopefully, when the situation does resolve itself with COVID, we'll be back to running at full capacity. So we're moving on now. What do you get out of this? So first thing is obviously the experience of going to tribunals and being able to put that on your CV. It was a case, I think, back in the early 2000s, so I hear, that saying I've done FRU was enough. Now, if you say I've done FRU, the next question is going to be how many? So it's a really, really important thing. When you look at, many chambers will do like like a pamphlet or something on the things that they look for, like a feedback on what pupillage applications were like this year and stuff like that. FRU is often name checked in there as a way of gaining valuable advocacy experience and experience dealing with clients. It's really good when you're in practice as well, because at least then you have an idea of what a solicitor does. And the second thing is, and just bear with me on this, is you get an opportunity to help people, really vulnerable people, and make a big difference in their lives. It's a way to put your skill set to use in a way that benefits society, and it also benefits you. And please believe me, there is no better feeling than walking out of a tribunal and having secured the result that you want, because you feel great and you feel great for your client, and you're essentially on cloud 9 for the rest of the day. And that's something that we want to help you achieve through volunteering here at FRU. Heloise, do you have anything to add?
Yeah, I'll try and be really quick because I'm aware people will want to ask questions. But doing a case with FRU is very useful for why do you want to be a barrister? What makes you a good barrister? Talking about the skills. It's much harder to do multiple cases in employment, particularly if you're thinking about this year's gateway. There is, of course, if you're thinking about the year after that, then sure, that's perfectly possible. I think it's really what you make of what you've done and explaining what you've got out of it and making the most of that. And I might add really quickly, we have had some remote hearings, but there are still in-person ones with employment as well. Okay, I think I should probably stop there.
Great, thank you very much, both of you. That was really, really interesting to hear. We've got quite a few questions, so I'll try and get through as many of them as we can. I'm just going to read some out off my screen. This one is kind of in two parts, and I think you might have covered the first one already, but do you know when training will resume, and is there funding available for those from low income backgrounds who may not be able to afford the training fee?
So as Nathan said, the next training days it will hold will be in the spring, and that would be looking to start volunteering in next summer. The fee is £50 for each training day, and that fee has not altered for a number of years. I mean, if somebody is in very dire straits, then I'm sure that they could, explain to us if they felt that that an exception should be made in their case. But in all honesty, I don't think it's an unreasonable fee, and I think that it also encourages people to actually come and take up their place, whereas otherwise people might not, and then somebody else wouldn't get their place.
Okay, and what has the FRU done to make itself more diverse and sustainable?
Okay, I'm going to take that question too, Nathan. Sorry, because I've been with FRU a bit longer. I think in terms of sustainability, the difficulty is that when you're dealing with cases, you're having to print off a lot of documents. So there's a limited amount you can do there. Now, obviously, the respondents are often doing bundles in our cases, and DWP are providing them sometimes in Social Security. But to a certain extent, that's something that's difficult to deal with. I suppose the fact that a fair number of things are now happening remotely probably saves some aspects sustainably. In terms of diversity, we reach out to clients from all backgrounds, and many of them are from very low income backgrounds and have disabilities. I'm not sure of the exact breakdown, but I think we do reach a very diverse group of people. And our volunteers really do come from all different backgrounds, and they are also very diverse as well. And we just try to be welcoming to everyone. So, for example, if you've got a disability and you think that might be complicated for you with a case and you want to know how that would work with you, just get in touch and let us know, and we can work out how to deal with it.
Great. And are there any particular skills and experiences you look for when someone's applying to volunteer?
I can take this one. No, there isn't. Essentially, the only requisite to becoming a volunteer with us is to go to a training day and to pass a test. We're not going to put limits on who can apply or anything like that in terms of you have to have done X many pupilages or what have you. That's not what the FRU is about. We're about giving people the first steps into their legal career. All we need to do is see that you have a grasp enough of the law to handle a case competently. That's the only requisite that we have for you coming aboard and taking cases. So training day, test, that's it.
And what can people expect from the tests?
I can answer in terms of Social Security. The test will have some sources attached to it, which is normally it's a statute, it's legislation, and it will have a few pages of that, and it will normally have one question on it, and it will be something like, Billy has been denied personal independence payment on the 28th. He submits for a mandatory reconsideration on the 29th. He doesn't file his appeal in 2 months. It will have something of that nature, and it will be deceptively simple as well. You'd be surprised how many people fail the FRU test. I think our pass rate's around 60%. So 40% of people will not be able to answer what it seems like a very simple question. And that's because there's normally like a few layers to that. But everything that you need to pass the test question is attached to the test paper. You don't need any prior knowledge. Obviously, we will have covered things in the training day, but this is a case of, can you read the statute? Can you pick out the relevant parts and can you apply it? And it is really that straightforward conceptually anyway.
And that's pretty much exactly the same with employment. We might give you a little bit of information about a hypothetical problem, but primarily it's about interpreting the statute.
Great. And regarding employment law, if the opposition at tribunal proposes to settle the case agreed by the client, do I have the power to settle the matter, or do I need further authorization, i.e. from my supervisor?
Anything that you do work-wise, application, settlement, you do need to talk to us about it. If you can't get hold of us and it's an emergency and it must be that exact moment, then obviously you go for it. The COT3 agreement, which sets out the terms, that's something that we need to see that and have talked to you about it. Essentially, we sign off on substantive work and we need to be happy with it. So yes, we would be involved in that conversation, but in an emergency, you have to sometimes agree.
Okay. And I understand the answer may be very fact-specific depending on the complexity of the case, but on average with the FRU, how long will you spend on one case in the tribunal?
It is very difficult to say. With your very first employment case, my very first one was 3 weeks. It was very intense. I was basically coming in every day. If you are not able to do that, but you can manage, a couple of days a week to devote to the case and maybe some more time here and there, you'd probably need a bit more like 4 to 6 weeks preparation time. And it can take longer because sometimes cases can be postponed. In terms of it's just really, really hard to put a figure on it, I'm afraid. You have to say you can do that hearing and you have to have enough of the time available to be able to do it. We can discuss that with people and try and work out something that would actually fit with their life better. But to a certain extent, we're going off what they're telling us.
For Social Security, we normally give you guys 2 weeks. That would be the standard limit for your first case. And we also factor in that 2 weeks that most of you will be students and doing something else along those lines. So we think 2 weeks, if you work on it relatively consistently over that course of time, you should be able to handle your first first tier tribunal case. So yeah.
I don't know if we're going to get kicked out now, but if we are, then please do come and ask questions on the FRU stall.
think we've just got time for maybe one more question just to squeeze it in. There's kind of a few quite similar questions that you could answer all together possibly. Who can apply, undergraduate, postgraduate, etc.? Do you need to have completed the bar vocational training to apply? And I'm in the first year of law. When would I be eligible to apply for training?
So that information is on the FRU website about applying to do volunteer, and I would probably recommend looking at that because I can't answer everyone's scenarios, but you have to have completed the LLB. You can be on the GDL. You don't have to complete the BPTC. Really short version.
Right. Okay. Great. So huge thank you to both of you for taking the time to speak to us today. I really hope that's been helpful for everyone. And do take a look at the FRU website if you need any more information.
Thank you, everyone.
Thank you very much.